May it please you, my lady, my lords. We were just about to start on causation. And essentially, Daiwa's argument under this heading is that the claim is defeated on the grounds of causation because they say the loss was caused by Singularis' own unlawful conduct. Having taken the issues in the order that we have, which we hope is the logical order, necessarily, if Daiwa's argument on attribution for the purposes of illegality has failed, then it doesn't have an argument on causation at all. The only world in which we would be talking about causation would be if the argument on attribution, Daiwa's argument on attribution, has succeeded in relation to the illegality issue, but the Daiwa argument on Patel and Mirza has also succeeded, because if we are wrong on Patel and Mirza, we don't get to causation. So the parameters within which the causation argument arise are defined by those two considerations. The fraud has been attributed, but the defense of illegality fails because of the approach taken in Patel and Mirza. Those being the sort of that being the framework within which the argument arises. The 2 points that Daiwa runs with in paragraph 83 of its case is that the loss, they say, is caused by Singularis' own dishonesty, and Singularis, they say, did not rely upon the due performance by Daiwa of the quince duty of care. Now, in relation to those 2 points, our answers can be given very shortly. So far as causation in the sort of but-for sense is concerned, is it true to say that loss was caused to Singularis by its own dishonesty? Our submission is no. Even assuming that Mr. Al-Sanaya's fraud is attributed to Singularis, the loss is caused to the company not by any dishonesty, but rather by Daiwa's breach of its duty of care, a duty which, as we say, only arises if it is on notice that there might be dishonesty. And the loss is caused immediately and directed by Daiwa acting in breach of that duty of care by paying out the money pursuant to the instruction it received. But for that breach, however dishonest Singularis has been, but for that breach, the money would still be sitting in the client account. So the loss is caused by the breach of duty by Daiwa. So far as Daiwa's second argument on causation is concerned, that is that Singularis did not rely upon the due performance by Daiwa of the quince duty of care, well, the short answer to that is reliance forms no part, no necessary element, in the claim for breach of the quince duty of care. One, no doubt, could find many companies whose directors were uniformly ignorant of the existence of a thing called a quince duty of care and did not rely in any subjective sense on it, but their state of mind is entirely irrelevant to the 2 questions. Do the circumstances give rise to the duty because a reasonably honest banker would have realized there was a real risk of fraud? And secondly, has that duty been broken? Neither of those turn on questions of reliance. And that is where there is a fundamental difference between the cases based on a breach of the quince duty of care and the cases based on a breach of auditor negligence. Because obviously the analysis that has been gone through, and we've seen it in Berg, we've seen it in Singularis, in Stone and Rolls, the analysis in the negligent auditor cases is that the company either does or doesn't rely on the negligent advice from the auditor, and that is what causes the loss. But that is not the quince situation. So those are essentially the very short answers to Malone-Friend's argument on causation. He took it orally very shortly. There is quite a lot more in his written case on causation, but which we have answered in our written case. And I don't think it necessarily helps you for me to paraphrase orally what we have already written. So I wasn't going to go through. Your ladyship, my lords, may remember the various cases that were cited in my landed friend's case of Stacey and Auto Sleeper, and Clay and TUI, and there's our answer to all of those, which is essentially that those are cases that my landed friend is seeking to rely on in his written case, are all about circumstances where a breach has occurred and then the claimant does something that may or may not break the chain of causation, but they are all about novus actus interveniens, that is, an intervening act after the breach of duty has occurred, whereas our case is exactly the other way around. The act upon which Daiwa would wish to rely is the fraudulent instruction, which is the precondition to the duty of care arising in the first place. So there's no question of a novus actus by the account holder intervening to break the chain of causation flowing from the breach of duty, because the duty only arises as a result of fraudulent instructions coming from the account holder. So I don't think there is anything in relation to causation that has been said orally that we haven't already answered in writing. So we can move on to the final issue, which is dealt with in my learned friend's written and oral argument, which is the supposed counterclaim in deceit, or what he sometimes characterises as the circuity of action. Now, that line of argument does, as my learned friend says, depend on the decision in Bearings, which he mentioned but didn't go to. And it would, I think, be helpful to go to two decisions in Bearings, because once one sees how they were decided, it is apparent that they simply do not support the propositions for which Malone Friend would wish to rely on them. So can we just go to them? They are both in Authorities Bundle 1, Primary Authorities Bundle 1. So the first one is at tab 2, and that's electronic, page 571. And this was the determination of some preliminary issues. The substantive claim was a negligence action by Bearings in liquidation against its auditors on the grounds that they should have discovered the unauthorised dealings. This first one, if I can call it Bearings 1, it calls itself Bearings 2, actually, but the second one isn't numbered. Anyway, this first one that we're looking at was the determination of a preliminary issue raised by the auditors, saying that they had an equal counterclaim against Bearings based on fraudulent representations made to them by the finance director of Bearings, and they were saying the finance director misrepresented to them about essentially his state of knowledge about the financial position of Bearings. Now, if we just very quickly go through this, because in fact, I mean, what is ultimately decided doesn't particularly help you, but it provides a necessary introduction to how the judge dealt with comparable issues differently in relation to the second Bearings case, which is really the one that my learned friend seeks to rely on. And one needs to see the difference between this first Bearings decision and the second Bearings decision in order to understand why my learned friend's arguments are wrong. So if we could very briefly just see what was in play and how it got decided. If we start in electronic page 580, page 36 of the hard copy bundle. And I won't read it all to you, but paras 31 to 37 set out essentially what the case was that the auditors, Deloitte and Touche, D&T, are the auditors, what their case was. And if one just goes to the next page, electronic page 581, and we look at para 37, you'll see that what the judge is saying, in order to make out their case in deceit, the auditors have to establish the following: one or more representations by Mr. Jones, he was the finance director of Barings, one or more representations by Mr. Jones, 2 which were false, 3 which were made deceitfully, in this case recklessly, so as to amount to deceit, 4 which were intended to and did induce the auditors to engage in or abstain from certain conduct, 5 which caused loss to Deloitte, that is, their liability in negligence was their alleged loss, 6 for which the relevant Barings company is responsible. So that was what was being alleged. And just to see how it was disposed of, ultimately it was essentially it failed on the facts if one just in the sense that the finance director was held not to have been deceitful. And one sees that if you just go forward to page 599 in the electronic bundle, page 55 in the hard copy bundle. We'll just pick up what was the judge's conclusion, having heard the evidence and reached his assessment of Mr. Jones. He says at para 115, therefore, on the basis of the evidence adduced for the purposes of this preliminary issue, the auditors have not established, to my satisfaction, that when Mr. Jones signed the representation letters, he did so knowing that statements in the letters were untrue, without an honest belief in their truth or indifference as to whether they were or were not true, or to knowing that he had no reasonable grounds to make the statement. So that was, in fact, the basis upon which the preliminary issue was decided. The claim in deceit failed. But his lordship then went on to discuss a number of other issues which are relevant to the second Barings decision. So it provides a helpful introduction because he refers back to his reasoning and paraphrases it later. So if we then go on and just look at page 601 in the electronic bundle, page 57 in the hard copy bundle, you'll see there's a section headed causation. And the first sub-issue he deals with is whether causation is a requirement at all in relation to a claim based on deceit, and he decides that it is. And then over the page 602, electronic bundle, page 58, he, in the middle of the page there, his next italicized subheading is causation established? And he refers to the different approaches that courts have taken to the question of causation and what one looks for. And essentially there are sort of 2 threads that he identifies. One is the but-for question, and the other is what he describes as Lord Hoffman's more policy-based approach, which is, well, what is the purpose for which the question of causation is being asked? So one sees in para 134, we have Lord Steyne in Smith New Court. The development of a single satisfactory theory of causation has taxed great academic minds, but as yet seems to me no satisfactory theory capable of solving the infinite variety of practical problems has been found. Our case law yields few secure footholds, but it is settled that at any rate in the law of applications, causation is to be categorized as an issue of fact. What has further to be established is that the but-for test, although it often yields the right answer, does not always do so. That has led judges to the pragmatic test, whether the condition in question was a substantial factor in producing the result. On other occasions, judges assert that the guiding criterion is whether common sense terms there is a sufficient causal connection. And then, I won't read all of that, but if you then look down at para 137 at the foot of that same page, we get Lord Hoffman in Empress Car, and you'll see just before the quote, Mr. Justice Evans-Layham refers to Lord Hoffman's more policy-based approach, and the quotation is there given, and the bits, without reading it all, if I can just flip over the page to para 138, where he quotes the first few lines, again, of Lord Hoffman. These examples show that one cannot give a common sense answer to a question of causation for the purpose of attributing responsibility under some rule without knowing the purpose and scope of the rule. Does the rule impose a duty which requires one to guard against or makes one responsible for the deliberate acts of third persons? And so he then decides at the bottom of that paragraph, towards the bottom of that page, paragraph 139. In the light of these authorities, it seems to me that under the head of causation, I need to have regard to both Lord Staines's test. Was the alleged deceit a substantial factor in producing the auditor's liability, and Lord Hoffman's regard for the purpose and scope of the rule, responsibility under which is to be attributed. And then he, just so that you see the logic of the sequence of his reasoning, if we go on to page 606, para 148, he says, accordingly, with some regret, I do not see that it's open to me to find, taking account either of a common sense approach to a factual causation or of the policy of the rules involved, that the auditor's signature of the audit certificates induced by the representation letters was not a cause of the auditor's liability. So he holds that their signature was. And then over the page, 2 pages on, he deals with vicarious responsibility, and at the very end, para 160, he says, accordingly, I found Mr. Jones's actions in signing the representation letters to have been had I found Mr. Jones's action in signing the representation letters to have been recklessly fraudulent, I should have held that Barings was vicariously liable for his action. So the strikeout attempt at that stage failed because the representations were made by somebody who was not deceitful, so there wasn't a cross-claim in deceit. We then get to the authority that my learned friend does want to rely on, which is the second one. And the relevant part, it is, as he says, an extremely long judgment, but the bits we need are of relatively limited compass. And if we pick it up at electronic page 726, which is page 182 of the hard copy bundle. This is the trial judgment. And the section of the judgment here is dealing with a very closely related point, but different, because here it was being said by the auditors that they have a cross-claim against Barings, not for the finance director having said he knew more than he knew, but in respect of Mr. Leeson's own frauds, the very frauds which they owed a duty of care to identify. So it was a similar attempt to get out of liability for negligence, basing themselves on a cross-claim in deceit. But the cross-claim here was based on the assertion that there were a number of representations made. I mean, the detail of them doesn't matter, but they're listed there on page 726 in paragraph 694. Those are the representations made by Mr. Leeson, which were said to give rise to the cross-claim by the auditors in that case. Just to run through the various issues that were dealt with, page 727, you see his lordship was dealing there with the question of whether or not there was vicarious liability for Mr. Leeson's misrepresentations, and he applies the course of employment test and the scope of authority test. And he comes to the conclusion at the very bottom of page 731 of the electronic bundle, page 187, paragraph 720, I therefore conclude Barings is vicariously liable for the fraudulent representations made by Leeson, upon which Deloitte and Touche rely. So he then deals with causation. He refers here, if we go on to the next page, to the tests he derived from Smith Newcourt and from the Empress Carr case, So they get a rather condensed recitation there. And then we pick it up at 724, where he draws the distinction between the previous case that he had decided and this one. He says at para 724, thus in the preliminary issue, Mr. Jones's representations to Deloitte and Touche induced Deloitte and Touche to sign off the accounts, and if they had been proved to be fraudulent, would have been treated as the sole cause of Deloitte and Touche being sued for negligence. That would have been so, even though another cause of Deloitte and Touche's exposure to suit was assumed to be their own negligence in conducting the audit. In the present case, however, there's a factor which was not present in the preliminary issue. In the preliminary issue, it was not alleged that Deloitte and Touche were negligent in failing to spot Mr. Jones's alleged fraud. In this case, the position is different. Looking at their representations individually, and then he runs through them. Then we go over, and he deals with, on the next page, the actual question of causation in relation to those various representations. And if we just see how he decides the points at 729 and 730, he says there's no doubt that Leeson's deceit and the signature of the audit certificate which it induced was a but-for cause of Deloitte and Touche's exposure. However, going on to the second inquiry described by Lord Nichols in Q8 Airways, I have no doubt as to my immediate intuitive response. It is that the auditors had a contractual duty to Barings to investigate the truth of the representations made to them by Leeson, just as they had a duty to investigate the accuracy of the trial balance provided to them at Leeson's instigation. They failed to investigate either properly, and Barings is suing them for that breach of duty. That breach is the cause of their loss. It makes no sense to say that Leeson's representations were the cause of Deloitte and Touche's liability than to say that his provision to Deloitte and Touche of a misleading trial balance was the cause. Both the trial balance and the representations were merely the subject matter upon which Deloitte and Touche should have exercised their professional skill and failed to do so. In the words of Lord Steyne and Smith Newcourt, in my view, the deceit by Leeson were not a substantial factor in producing a result, that is, D&T's exposure to suit. This contrasts with the preliminary issue, in that there was no allegation that Deloitte and Touche should have detected the falsity of Mr. Jones's representation letters. So we say the logic of what is being said here by His Lordship, we say it's entirely correct, is that what matters is whether or not the breach, what matters for the purposes of causation, is the question whether or not the duty was a duty to detect exactly the misrepresentation, so to speak, or the deceit, which gives rise to the claim against the auditor, in that case, the broker in our case. And then he deals at 731 over the page with a point which, again, is almost exactly the same as the point my learned friend is running, that somebody can't profit from their own dishonesty. He says at 731, there are two factors to set against this immediate intuitive response. The first is decisions going back to Raynal and Spry to the effect that it's no defence to a claim for deceit, that the claimant was negligent in believing the defendant's false statement. However negligent the party may have been to whom the incorrect statement has been made, yet that is a matter affording no ground of defence to the other. No man can complain that another has too implicitly relied on the truth of what he has himself stated. One sees essentially exactly that or not that authority in my learned friend's argument. But the answer comes in the next two paragraphs. That might appear to cover the situation here. However, I think a distinction must be drawn. Lord Cranworth was dealing with a common situation where A makes a fraudulent statement to B believes it, even though he should not have done so if he'd made proper inquiry. In that sense, B was negligent, but the cases decide that A can't say, you shouldn't have believed me, nor A's employer say, you shouldn't have believed him. The present case is different. Here, B was under a pre-existing contractual duty owed to A's employer to test the truthfulness of A's statement. Had B performed his duty, he would have realised the statements were false. B failed in that duty, and he believed the statements. His only loss is his liability to A's employer for the failure to perform that duty. A's employer can say it was your job to check the truth. A's employer can say it was your job to check the truth of what A said. You cannot sue me for being deceived when you have done your job, when if you had done your job, you would not have been. And that, again, in our submission, exactly reads across to our situation and explains why there is no counterclaim here based on deceit.
Is the correct approach to this not to say that if, rather than saying that Daiwa have a counterclaim against Singularis for deceit in respect of the damages that they have to pay to Singularis, to say instead that this is a situation that falls within the scope of the law of contribution, and to say that Daiwa would be entitled to seek a contribution from Mr. Al-Sania as being somebody who was liable also to Singularis in respect of the same damages.
Yes.
And the court could, in fact, if it thought it was fair, order that Mr. Al-Sania should indemnify Daiwa against the liability.
Indeed. And I'm grateful. There's more good stuff about the purpose and the scope of the rule in relation to which the question of causation is being tested. I don't propose to read, but could I commend to you respectfully paragraphs 739 through to 743, where, again, His Lordship derives the sort of assistance we invite you to derive from Reeves, the suicide in custody case, and find that the section ends at 743 with Mr. Justice Evans' name saying, likewise, in the present case, the auditors were in breach of a duty to detect representations of the very type that were made. To adapt Lord Hoffman's words only slightly, it would make a nonsense of the existence of that duty if the law were to hold that the occurrence of the very act which ought to have been prevented gave rise to an equal and opposite counterclaim and thereby negatived causal connection between the breach of duty and the loss. That is how His Lordship decided that case. That being the position, the case does not support the propositions which my learned friend sought to derive from it. He says, and it may be convenient to look at paragraph 102 of his case, which is page 94 of the core volume. He says, and he summarizes very briefly orally, but making the same point. He says at para 102, the reasoning that led Mr. Justice Evans Lone to conclude that the counterclaim in bearings based upon Mr. Leeson's fraud fails does not apply in a situation where the deceit that is practiced upon the auditor or bank or broker is that of the one individual who owns and controls a one-man company whose state of mind is to be imputed to his company, as it was in Tan. The company will then be primarily responsible for the deceit, and as submitted above, it is very difficult to conceive of a duty, the purpose of which is to protect a person, natural or corporate, from the adverse effects of his, her, or its own fraud or dishonesty. In short, the very thing analysis doesn't apply where the company itself is culpable of fraud. With the greatest respect, that is simply incapable of being derived from the Bearings decision. The Bearings decision proceeded on the basis that that Bearings would be liable for Leeson's fraud. But the claim failed on grounds of causation. It had nothing to do with whether Bearings was or wasn't a one-man company. It had nothing to do with whether Bearings would have been primarily or vicariously liable for the fraud. It failed, as we have seen, because it would make a nonsense of the law for it to succeed. And that's got nothing, as we say, to do with one-man company, primary rather than vicarious liability, or how many shareholders there are, who the beneficial owner is. It's just a question of a sensible purposive application of the test of causation to the circumstances. And we submit that that should encourage you respectfully, we would say, my lady and my lords, to the conclusion that exactly the same outcome should have arrived at this case, which is exactly what the Court of Appeal themselves decided in dealing with the matter. I don't think we need to go to it, but it's dealt with clearly in paragraphs 73 to 80 of the Court of Appeal's judgment. So for those reasons, we submit that the counterclaim on deceit doesn't work, and that, I think, is in fact all that I wished to address you on, unless there are other questions.
I keep looking for them and I don't find them.
I'm disappointed.
Thank you very much, Mr. Crowe. Mr. Mester?
No, My lady, my lords, may I begin with the submission made by my learned friend that Singularis must be regarded as the victim of Mr. Alcenea's fraud. That is a proposition which lies at the heart of many of the submissions which my learned friend has made in the course of this morning and this afternoon. And with great respect, in making that submission, my learned friend fails to take account of the distinction that is established in Bilter, and to which I drew attention at the outset of my submissions, between cases in which the company sues its delinquent director and cases in which the company sues a third party. And that is a very important distinction. And if I might invite my lady and my lords to look back at a Bilter, which is in the, I'll give the hard copy reference first, Primary Authorities Bundle tab 5, and I wish to start at paragraph 7 of the judgment of Lord Neuberger, which is at page 358, and the electronic reference is on its way, I hope. 902. Paragraph 7 of Lord Neuberger. There, Lord Neuberger says, so far as attribution is concerned, it appears to me that what Lord Sumption says in paragraphs 65 to 78 and 82 to 97 is effectively the same in its effect to what Lords Toulson and Hodge say in their paragraphs 182 to 209. Both judgments reach the conclusion which may, I think, be stated in the following proposition: where a company has been the victim of the wrongdoing by its directors, or of which its directors had notice, then the wrongdoing or knowledge of the directors cannot be attributed to the company as a defence to a claim brought against the directors by the company's liquidator in the name of the company and or on behalf of its creditors for the loss suffered by the company as a result of the wrongdoing, even where the directors were the only directors and shareholders of the company, and even though the wrongdoing or knowledge of the directors may be attributed to the company in many other types of proceedings. And then if I could show my ladies and my lords one of the passages in Lord Sumption's judgment which is referred to here, which starts at paragraph 91, which in the hard copy is page 388 of the bundle, and in the electronic copy I'm sorry, electronic bundle, page 932. And if you have that, what Lord Sumption says is the position is different where the company is suing a third party who was not involved in the director's breach of duty for an indemnity against its consequences. In the first place, the defendant in that case, although presumably in breach of his own distinct duty, is not seeking to attribute his own wrong or state of mind to the company or to rely on his breach of duty to avoid liability. Secondly, as between the company and the outside world, there is no principled reason not to identify it with its directing mind in the ordinary way. For a person, whether natural or corporate, who is culpable of fraud, to say to an innocent but negligent outsider that he should have stopped him in his dishonest enterprise is as clear a case for the application of the illegality defence as one could have. Stone and Rolls was a case of just this kind. Leaving aside the admittedly important question of the scope of an auditor's duty, if the illegality defence had not applied in that case, it could only have been because the company was treated in point of law as a mindless automaton, or the defence could never apply to companies, even in circumstances where it would have applied to natural persons. Neither proposition is consistent with established principle. And then if I might read on, the technique of applying the general rules of agency and then an exception for cases directly founded on a breach of duty to the company is a valuable tool of analysis, but no more than that. Another way of putting the same point is to treat it as illustrating the broader point made by Lord Hoffman in Meridian, that attribution of legal responsibility for the act of an agent depends on the purpose for which attribution is relevant. Where the purpose of attribution is to apportion responsibility between a company and its agents so as to determine their rights and liabilities to each other, the result will not necessarily be the same as it is in a case where the purpose is to apportion responsibility between the company and a third party. That makes it unnecessary to address the elusive distinction between primary and secondary victimhood. That distinction could arise only if the application of the breach of duty exception depended on where the loss ultimately fell, or possibly on where the culpable directors intended it to fall. If, however, the application of the exception depends on the nature of the duty and the parties as between whom the question arises, the only question is whether the company has suffered any loss at all. So, my lords, we would entirely accept that if one were dealing with a claim by Singularis against Mr. Alcinea for breach of his duties, then it would be the case that Singularis was the victim of Mr. Alcinea's fraud and that he had misappropriated the company's assets. We take no issue with that in that context, which is obviously right, and he could not attribute his own wrongdoing to the company in order to defeat the claim against him. And my lords and my lady, just before leaving Bilter, if I might just go back to the passage which my Lord Reid drew to my learned friend's attention, which is at page 367 of the bundle, which is electronic reference 911. It's paragraph 44 in the judgment of Lord Mance, in which his lordship says, it follows that I would, like Lords Toulson and Hodge, endorse the observations of Professor Watts and Professor Francis Reynolds, QC, as editors of Bowstead on agency, in relation to the argument that a principal should be attributed with the state of mind of his agent who has defrauded him, so as to relieve either the agent or a third party who had knowingly assisted in the fraud. And then the quotation is, such arguments by defendants, though hazarded from time to time, are plainly without merit. However, in such situations, imputation has no reason to operate. The rules do not exist in a state of nature such that some reason has to be found to disapply them. Whether knowledge is imputed in law, it turns on the question to be addressed. And the only point I wish to make by reference to that is that Lord Mance is clearly dealing with the situation in which the principal is suing the agent for breach of the agent's duty, and he makes the point that anyone who knowingly assists in the agent's fraud is to be treated no differently from the agent himself. We take, of course, no issue with that, but we are dealing in this case with a different context, namely a context in which the company is suing a third party in negligence.
Negligence rather than for knowing assistance.
Yes, that's right. But, my lord, that is, with respect, a very important difference, because in the knowing assistance case, which would now be called dishonest assistance, of course, since Tan, the party being sued, if found liable, will be dishonest. And in the present case, the primary claim brought against Daiwa at the trial was that it had knowingly assisted in Mr. Alcenea's breach of his fiduciary duties. And we successfully resisted that on the facts, but we accepted that if a finding of dishonesty had been made against Daiwa, then there would be no defence.
But doesn't the rationale given by Professors Watts and Francis Reynolds in the second quotation apply also to a situation where a duty is owed in negligence, so that the assistance is by breach of that duty of care? It's the passage being, the simple point is that. I rather took that to be one of the points that Mr. Crowe was making, that...
With respect, this has to be read, I would suggest, in the context of whether or not, in a claim against the agent by the principal, the agent can attribute his or her own dishonesty to the company in order to defeat the claim.
Yes, thank you.
It is, I would respectfully suggest, entirely clear from Bilter that where one is dealing with a claim in negligence against a third party, the reasoning which holds that there shall not be attribution in a claim against the dishonest director or anyone who dishonestly assists the dishonest director does not apply in the case of a claim in negligence, and one sees that from the passages in the speech of Lord Sumption, to which I have just drawn attention. My lady, my lords, we say that the starting point in our submission for the purposes of this claim is to ask whether the dishonest acts of Mr. Alcenea in giving the payment instructions are to be attributed to his company. That is the starting point in our submission. My learned friend sought to start with the question of illegality, but I would respectfully suggest that that is putting the cart before the horse. One should start by asking the question, were the payment instructions the act of the company? And in my submissions, I placed considerable reliance upon Lord Reid in Tesco and Natras, that a persona ficta must think and act through natural persons, and the distinction which he draws between the acts of a mere servant or agent and the mind of a mere servant or agent and the mind of someone who must be treated as being the company itself. And that is an obvious point which flows from the fact that a company is a creation of the law. And my learned friend, in his submissions, with great respect, he did not refer to Lord Reid and does not grapple with the points that we were making. He is, in essence, saying, my learned friend, that the nature of the Queen's Care duty means that the act of giving dishonest instructions to the company's bank can never be regarded as the act of the company, even if the company has only one director and one shareholder. And there is, with great respect, in our submission, no reason why that should be so, and very sound reasons of principle why it should not be so. And my lady and my lords already have my submissions that to adopt such a position would involve treating a company more favourably vis-à-vis third parties than a natural person. Now, in relation to that, my learned friend did not disagree, as I understood his submissions, with the example I gave of suppose that Mr. Cass, in the Lipkin case, had been the only partner of the firm and had given the payment instructions dishonestly. I submitted that it would be an absurdity to allow Mr. Cass in that situation to sue the bank, or indeed his trustee in bankruptcy to sue the bank for breach of the Queen's Care duty. And my learned friend did not appear to take issue with that. His answer to it was to say, well, it makes all the difference if the business is being carried on by a limited liability company, even if there is only one director and one shareholder who is giving the dishonest instruction. And that is clearly not the view that was taken by Lord Brown in Stone and Rolls, which of course was dealing with auditors, but my lady and my lords will recall that the passage in which Lord Brown says it makes no difference that the business would be carried on by a one-man company. And the only suggested reason given by my learned friend as to whether it should make a difference is that a company has a separate legal personality. And of course, we do not disagree with that. It does have a separate legal personality. But equally, and going back to Lord Reid and indeed Lord Hoffman in Meridian, a company can only think and act through natural persons. And if there only is one natural person who is the only shareholder and director, my lady and my lords already have my submission that the guilty mind of that person must be treated as the guilty mind of the company. The other point that we made in this regard as to why to say that the instruction can never be regarded as the act of the company was that a company should not be treated as a mindless automaton. And I've just shown my lady and my lords the passage in which Lord Sumption used that phrase in Bilter. And we have submitted that the mind of the company must reside somewhere. And in relation to that, with great respect, we did not discern any coherent answer given by my learned friend as to how the company could be anything other than a mindless automaton in such a situation, or as to how it could ever be appropriate for the company to be treated as a mindless automaton in giving payment instructions to its bank. So the next point that my learned friend sought to develop, no doubt with a view to avoiding that difficulty, concerned the role of the other directors. And that gave rise to a number of criticisms, wholly unjustified in my submission, as to the way in which we have put our case. It is convenient to start at this part of my submissions with something that my learned friend said in relation to the other directors. According to my note, he said that the other directors were not active in management, which is factually accurate. But if one, your lordships and my lady will recall paragraph 161 of the speech of Lord Walker in Stone and Rolls, in which he set the test in relation to other directors as to whether there were other directors who were involved in running the company. And my learned friend's acknowledgement that the other directors were not active in the management of the company effectively makes the case that we are making and demonstrates that they are not to be counted for these purposes. In the same context, it was said that, well, the other directors were innocent. They were not involved in or aware of Mr. Al-Sanea's fraud. That is, of course, a different point. If they are not involved in managing the company because they are inactive, they are likely to be unaware of what is happening within the company. But their innocence, born of inactivity and therefore not being involved in the company, does not permit, in my submission, the conclusion that a company which, had it been run just by Mr. Al-Sanea himself with no other directors, which would have been a one-man company, is to be treated differently. There is, in reality and in substance, no difference between those situations, and there is no difference, given the learned judge's findings of fact, between this case and the case of the nominee directors in Stone and Rolls, or the solicitor director in Berg, or indeed Mr. Tan's wife in the Royal Brunei case. And as far as Berg is concerned, my learned friend said, well, that was a case which did not involve dishonesty on the part of the director. That is correct. However, it was a case in which the mental state of the director, that is to say his knowledge, was attributed to the company with the consequences that I have already dealt with. And it is also to be noted, and I would invite my lady and my lords to note, that in the passage in Stone and Rolls at paragraph 161, Lord Walker places specific reliance on both on Berg and on Tan in setting the test which he sets out there for when a company is to be treated as a one-man company. Before leaving this topic and before leaving paragraph 161 of Lord Walker, in my learned friend's submissions, he also, with respect, failed to deal with or draw attention to the passage towards the beginning of that paragraph in which Lord Walker referred to the situation in which there was a single dominant director and shareholder to whom the other directors were subservient. And it's quite clear that Lord Walker in that passage was regarding such a company as a one-man company. And it is striking, I would suggest, that my learned friend did not attempt to address what I would respectfully suggest were important points that I made yesterday, namely the judge found that Mr. Alsanea was the dominant influence over the affairs of the company, which involved necessarily a finding that the other directors were subservient, that it was accepted by Singularis that Mr. Alsanea was the dominant mind and will of the company, and that in all those circumstances it could not realistically be suggested that the other directors were performing the function of directors or were involved in running the company. And so if I might invite my lady and my lords to look back at a passage in our written case which my learned friend drew attention to and criticised. It is paragraph 37, which appears on page 75. You may recall he drew specific attention to this. It follows that a one-man company is one where there is no other person concerned in the management and ownership of the company other than the fraudster and those who are taken to have known of the fraud. He accepted that that was accurate. And then the second sentence says, the appointment of an innocent but inactive director who exercises no executive function does not prevent the company from being a one-man company. And in my respectful submission, that sentence is entirely accurate and correct and follows from what Lord Walker says in paragraph 161 and from the learned judge's findings of fact. My lady, my lords, next it was said by my learned friend that our arguments would make a nonsense of the Queen's Care duty. And that submission, with great respect, fails to focus upon a distinction which I drew attention to in the course of my submissions yesterday between the situation in which a payment instruction is given by a mere servant or agent of a company, and in relation to that, I fully accepted that that is the very situation that the Queen's Care duty is designed to deal with, to protect the company against a fraud being committed by a mere servant or agent. But it was my submission that where the instruction was given by the company itself, and going back to Lord Reed's passage, that is to say the act of the company itself, then that was a different situation. And it certainly does not make a nonsense of the Queen's Care duty to find that where, on the facts of a given case, the payment instruction must be taken as the act of the company itself and to be dishonest, that the Queen's Care duty should have no effect, as the learned judge held. Because in that situation, as I have submitted, the company is a dishonest person and is responsible for its own loss. There was a suggestion in dealing with Reeves from my learned friend that the very thing that the Queen's Care duty was designed to protect against included the company's own dishonest act. My lady and my lords already have my submissions about Reeves. It is a very different situation, and we do say that it is very difficult indeed to conceive of a duty of care, the very purpose of which is to protect a person, whether natural or corporate, from its own dishonest acts. Such a duty would be really very difficult indeed to conceive of. So, To summarise, as you are aware, we say that the payment instructions must be regarded as having been given by the company in circumstances where it was itself dishonest. And that is therefore the context in which one approaches the consequences of the dishonesty of the company. And in relation to that, my lady and my lords, have our submission that we first of all say that the company is the cause of its own loss, and we have put that in various ways, and we have relied upon Luscombe and Roberts. In relation to causation, my learned friend has drawn attention to bearings and has submitted that the propositions that we seek to rely upon simply cannot be derived from bearings. And in making his submissions, again, with respect, he fails to draw a distinction between the situation in which a company is vicariously liable for the deceit practiced by one of its employees or officers, and the situation in which the deceit is the deceit of the company itself, for which it is primarily responsible and liable. And that is a very material distinction, and it is to be noted, and I would invite my lady and my lords to note that in bearings, in the passages which my learned friend showed you, they are under the heading of vicarious liability. And if I might just go back to look at some of those, you will find bearings in the primary authorities bundle. Forgive me. At its primary authorities, page 183. I'll just give you a tab reference. Tab 3 in volume 1. And if I might invite you to go to go to page 183, 727 in the electronic version. And on page 183, just above paragraph 698, one sees the heading vicarious liability. And so this entire passage is concerned with the circumstances in which the employer would be vicariously liable for the tort of deceit of the employee. And then if I could ask you to go to I'm so sorry, I'm trying to read my own writing. Paragraph 733, which is on page 190 of the hard copy bundle, and the electronic reference is 734. And if you have that at 733, Mr. Justice Evans Loam says the present case is different. Here, B was under a pre-existing contractual duty owed to A's employer to test the truthfulness of A's statements. Had B performed his duty, he would have realised the statements were false. B failed in that duty and believed the statements. His only loss is his liability to A's employer for failure to perform that duty. A's employer can say it was your job to check the truth of what A said. You cannot sue me for being deceived when, if you had done your job, you would not have been. Now, that is plainly dealing with a situation of vicarious liability, because it envisages an employer who is different from the employee who told the lies. But where one has a company which, let us suppose, has one director and one shareholder, the reasoning in paragraph 733 cannot have any application, because the employer is not in that situation in any way unaware of what the true position is, because it is only one individual who knows all there is to know. And you already have my submission that on the facts of this case, Singularis was no different. And if one takes it a bit further and supposes that Mr. Leeson had been the only director and shareholder of Bearings and had misled the accountants as to the true state of the accounts, then in my submission, the result would have been the opposite to what was in fact reached, because in that situation, the company itself would be dishonest. It would know all there is to know and could not sensibly claim that it had suffered any loss at all by reason of the auditor's negligence. My lady, my lords, it is also said, well, in this case, Daiwa was very negligent, and my learned friend spent some time on that. We do not, of course, dispute the learned judge's findings of fact in relation to the breach of the duty of care, but in all of these cases, including Luscombe and Roberts, Stone and Rolls, and the other cases to which I have referred, one is necessarily dealing with a situation in which there has been negligence, but where the issue is whether the dishonesty of the relevant individual is to be attributed to the company and what effect that has on the claim. And you already have my submissions about that in relation to causation, and I will not repeat them. As far as ex terpi causa is concerned, again, you already have my submissions, which is that once it is accepted, if my lady and my lords accept that Mr. Alcener's dishonesty is to be attributed to the company, then this is manifestly an action which is founded upon the company's own fraud and dishonesty. And if I might remind what Lord of 91 of his judgment, that is as clear a case as one can get of a situation in which the illegality defence would apply. And my learned friend says, well, it is actually a matter for evaluation by the trial judge of the various of the three tests set out in Patel and Mirza, and that an appeal court should not interfere with the trial judge's evaluation. A number of points about that. First of all, the application of the three-stage test is by no means an exercise of judicial discretion. If there has been an error of law or an error of principle, then an appeal court may certainly interfere with the finding of the trial judge. Secondly, we say that there is a very clear error in relation to illegality, in that the judge below and the Court of Appeal have failed to reach the conclusion that where the company is treated as dishonest, its claim fails by reason of being an action founded in fraud. And I have already given my submissions as to why that is a clear case. I will not repeat them, but that is what we say. My lady, my lord, subject to prompting from behind or from my right, and subject to any questions which you may have, those are my submissions.
Thank you. There are no questions, and I see no prompting. Thank you all very much indeed for your very helpful submissions. We will now go away and try and work out what the answer is, and we will let you know that answer in the usual fashion, no doubt in another country. Court will now adjourn.